All right, let's go on the record on DC 226174, Shanta Jones versus Valiant Enterprises LLC. Counsel, make your appearances.
Joshua Lee for the plaintiff, Shanta Jones.
And Christopher Lawless and Alex Caravio for defendant Valiant Enterprises Incorporated.
Have you guys submitted a notebook for me with, because there's quite a bit of briefing on this?
Yes, Your Honor. I think our legal secretary sent it to you yesterday.
Okay, let me go find out. Let me put you on hold 1 second. Okay, you may proceed. I've already read everything.
Thank you, Your Honor. I think I'll begin since it's defendant's motion we're here for, the hybrid no evidence and traditional motions for summary judgment. Defendant is moving on no evidence ground for each of plaintiff's claims: the negligent activity claim, the negligent undertaking claim, the premises liability claim, and the gross negligence claim. We are moving for traditional summary judgment on the negligent activity claim, the negligent undertaking claim, and the gross negligence claim, excluding the premises liability claim under traditional. Your Honor, since you've read the documents, is there any way you would prefer I approach this? Do you just want me to start from the top and go down?
No, I'll have some questions for you, but you can get started.
Okay. Well, we'll start first with no evidence, then I believe. Starting first with the negligent activity claim, Your Honor, it's defendant's contention here today that there is no evidence for breach of duty or causation. Plaintiffs responded to the no evidence summary judgment motion with argument that defendants have breached the standard of care and that the causation was caused by the failure to address a ceiling. However, in that same response, they admit that they're not bringing any claims from a negligent activity or contemporaneous negligent activity. So I'm a bit confused here on how they're asserting there's evidence of a negligent activity claim when they're not bringing any claims on a negligent activity. But to address their response to no evidence, the standard of care that they're asserting is that there should have been these inspections. There is no evidence that these inspections were contemporaneous to the accident in question that occurred on December 15th, 2021. That's just an argument under premises liability that they're trying to assert as a breach of duty under negligent activity. And as far as causation for failure to address the ceiling, the failure to address the ceiling is the breach of duty for premises liability, the correction of the condition of the premises, Your Honor. So neither argument addresses the no evidence for breach of duty or causation for a negligent activity claim. And so that's why defendants are
let me ask a question here. So is there any question that the plaintiff was an invitee at the time of this accident?
No, she was a resident of the apartment complex.
Okay, so you're not contesting that she's an invitee?
Correct, Your Honor.
Okay, go ahead.
So then to move along to the next claim, the negligent undertaking claim, again on no evidence grounds, defendants contend that there is no evidence of an undertaking or a promise, a breach of such promise, and there's no evidence of reliance by plaintiff on that promise or any alleged promise. In plaintiff's response to the no evidence summary judgment on the negligent undertaking claim, they assert that the undertaking that defendant did was performing these weekly inspections of the property. That's a bit of a circular argument because the premises liability standard that is brought is that these inspections were required. In fact, they retained an expert that says these inspections were required to meet the standard of care. So what plaintiff is in effect arguing here is that defendant is required to do these inspections per premises liability claim, but by doing these inspections, they're performing a negligent undertaking, and there's no case law to support that defendants are required to undertake this extra burden or extra claim simply by doing inspections that are required by the standard of care for premises liability. So I don't think that argument holds to show that there was any promise or activities done by defendant that caused an increased duty of care. The duty was already there for premises liability. Negligent undertaking is a separate claim. Also, as far as breach of duty, again, they're saying there was no contemporaneous activity. So these inspections that they're asserting were not contemporaneous. Any alleged breach of these inspections was not contemporaneous. And there's no evidence that plaintiff even knew these inspections were going on to show any kind of reliance on these inspections. So despite plaintiff's reliance on these inspections for a negligent undertaking, there's just no evidence there. That's simply, again, the premises liability claim.
Okay.
And then moving right along to the premises liability claim, defendant only asserts no evidence to the element of unreasonable risk here, Your Honor. Unreasonable risk has to be foreseeable and it has to be sufficiently probable to be an unreasonable risk. Defendant holds there's no evidence that it was sufficiently probable that this ceiling was going to collapse.
What wasn't there complaints made about this ceiling prior to the incident, or at least there's a fact issue on that?
Plaintiff alleges that she complained about the ceiling hanging the day before the accident on December 14th when the accident occurred on December 15th, Your
Honor.
Okay. But as far as sufficiently probable and foreseeability, the complaints of this ceiling were that it was hanging, what I understand from the expert testimony, a few inches from the side of the wall, I guess. Otherwise, there were multiple nails in the ceiling, multiple nails attaching it to its foundation. There was no indication, there's no evidence of testimony that this ceiling was in any way about to fall, other than this large wind came in and just happened to catch it. I think the sufficient probability standard, there was no sufficient probability the ceiling was going to fall. No evidence of that, absent this wind event or this unforeseeable cause of nature. Plaintiff responds that with the testimony of Kevin Gregg, a groundskeeper or pool guy essentially for defendant, and Gregg's testimony that he had seen prior hanging ceilings in the past. Most recently, to his knowledge, 6 months prior to the date of the accident, and then as far back as several years. The problem with plaintiff's reliance on Mr. Gregg's testimony is, one, Mr. Gregg might have seen hanging ceilings, but they didn't cite any testimony where he saw these ceilings fall. So just because he saw hanging ceilings does not create any sufficient probability that they would fall. There's no testimony cited by plaintiff that Gregg knew that. Furthermore, they're trying to, I guess, impose Gregg's knowledge of these prior hanging ceilings that occurred before defendant ever took management over the property. I can't stress enough that defendant only managed his property for 6 weeks prior to the accident. And during that 6 weeks, there's no indication that defendant Valiant had ever seen a hanging ceiling, no evidence of record that any ceiling had ever collapsed or fallen or been blown by the wind during those 6 weeks. And any imposition of a low-level employee's knowledge from his time before his employment with defendant is extremely overburdensome on businesses. There's no case law cited that kind of standard is placed on businesses for them to have all the knowledge of every employee, including low-level employees. So just because Mr. Gregg knew of some hanging ceilings long before Valiant took over the property, that's not sufficient to show that some risk is foreseeable or sufficiently probable, Your Honor.
Wouldn't he have an obligation to report that to his superiors?
I don't think Mr. Gregg would have an obligation to report that there was a hanging ceiling 6 months to several years prior to Valiant taking over the property. No, Your Honor. If he saw it while Valiant was managing the property, I think if he saw a condition of the property right then and there, yes, he would have an obligation to report that. But that's not what we're talking about here, Your Honor. We're talking about trying to impose his knowledge from several months to years back onto a new employer that hired him a few weeks before the accident in question.
Okay, do you have anything else?
Just moving along to the no evidence on the gross negligence claim, Your Honor. Defense argues there's no evidence of an act or omission which involved an extreme degree of risk, which to some extent we just spoke of. And we argue there's no evidence of a conscious disregard of plaintiff's safety by defendant Valiant. With regards to the act or omission of the extreme degree of risk, Your Honor, I just argued that it's not even an unreasonable risk for the premises liability standard. All that applies even more so to whether or not it's an extreme degree of risk under a clear and conscious standard for gross negligence. That just plaintiff makes the same argument that Greg's prior knowledge should have been imposed onto defendants, but Greg was a low-level employee. For gross negligence, it has to be a vice principal's actions, not a low-level employee. So if you look at the 1997 Texas Supreme Court case, Hammerly Oaks v. Edwards, or as recently as 2005 with Quest International Commissions versus AT&T, Texas law has consistently made it very clear it's got to be a vice principal's actions for gross negligence, not some knowledge of the landscaper / pool boy. So Greg's knowledge does not show any kind of conscious disregard or extreme risk or anything of that nature, Your Honor. And so as far as no evidence summary judgment motion goes, that's defendant's position on no evidence. Do you want me to continue into traditional, or would you like to have plaintiff respond on no evidence?
Are you here to get married, ma'am?
My friend is, yeah.
Okay, great. Miss Banfield?
Yeah.
Okay. All right. Go ahead. Let me hear a response.
Sure, Judge. Excuse me. I'm getting over a little bug, so I apologize if my voice gives out a little bit. So first thing I'd like to talk about, Judge, is I do think that ultimately after the trial of this case, that this case is going to be submitted on a premises instruction, not a negligence instruction. I agree that it would be error to submit both questions, and based on the nature of the claims in this case, it's more than likely that the premises instruction with the Corbin elements is the right instruction to submit. That being said, the Texas Supreme Court and the Dallas Courts of Appeals have made perfectly clear that the plaintiff can assert both premises liability claims and undertaking claims and gross negligence claims together. The only mutually exclusive claims are the premises and contemporaneous negligent activity claims. Those two cannot be asserted together, whereas the others can. So that being said, first on the negligent undertaking claim, I think that the circularity that Mr. Lawless is pointing out is simply a misunderstanding of the nature of the claims. The undertaking claim has to do when a person, in this case, this property management company, takes on a duty that they did not need to do, right? And so they chose to go about doing these weekly and monthly inspections. And it is clear from the contract that is between these parties. It is clear from the infrastructure of the apartment itself that Miss Jones necessarily had to rely on the property management company's reasonable conduct in this regard. For one, there's only one way in and out of her apartment. It is that stairway where she was struck by the falling ceiling, which means that she relied each and every day when she entered in and out of her unit that they did their job to inspect the property and make sure that they caught any unreasonably dangerous defects. Secondly, the contract itself states that she is not allowed to do repairs herself to those common areas, and so she had to rely on the property management company to identify those issues and repair them. So that I think is the basis, the factual basis and the legal basis for the undertaking theory. Whereas on the premises theory, the issue is not whether they have a duty to do a reasonable inspection, although that certainly can inform the question of whether they acted reasonably in causing the injuries or not. But really, the duty, as the court certainly knows, is that the property management company must warn or make safe an unreasonably dangerous condition. Now, an inspection might be needed, an adequate inspection might be needed in order to as part of that discharge of duty, but it's not necessarily exactly the same thing. And so there is no circularity problem, as Mr. Lawless is attempting to argue.
I guess what case law do you have that would support your position that a negligent undertaking would be appropriate in this fact pattern, where there's an inspection requirement?
So let me see if I can, I couldn't find a specific case dealing with a negligent undertaking that took the form of an inspection, Judge. We did cite a few cases in our brief: the Stirrup case and the Torrington case is obviously the seminal case on that from the Supreme Court, as well as there's, I believe it was the Crooks case, if I'm remembering right, but let me just check. Yeah, the Crooks versus Moses case. But those didn't necessarily have to do with a property manager doing an inspection or undertaking an inspection, but stands for the proposition that this is a cause of action, that if you have facts that fit these elements, it's appropriate to submit an instruction on these bases. And I think that because it is an independent and separate theory, the same evidence can support two different claims. There's nothing wrong with that, Judge, especially in a situation like this where you've got multiple different things going on at different times with different individuals, like repairmen and this groundskeeper or the manager, all doing different things. I think it's just a straight application of the elements that we can find in those cases.
And then there was an argument made that I thought was interesting that said that in order to assert a premises liability case or gross negligence, I guess, or a gross negligence claim, that you would have to have the vice principal would have to have knowledge of the dangerous condition. I've never heard that. So is that, let me just ask my question just a second. Just a second.
I'm sorry, sir. I'm sorry, Judge.
I'm trying to ask the question. So what case law do you have to support that or refute that?
It's a new argument that I haven't had the opportunity to brief, but I am a little bit familiar with this, Judge, because I have looked at gross negligence many times. It's partially correct. It's partially correct that a vice principal's knowledge is needed to support an element of gross negligence. It can be a vice principal. It can also be, under the statute, a manager with the ability to hire and fire. It can be somebody who's a department head or a manager of a sub-department. It can also happen, it can also support gross negligence where the company or a vice principal or a manager ratifies the conduct or approves the conduct ahead of time. And so I think we do have some fact issues on that, where the property manager herself is approving of the way in which the folks like the groundskeeper perform their quote unquote inspections on a weekly and monthly basis. And so it wasn't raised in the briefing, but it is something that I believe there's evidence for, and I'm happy to submit supplemental briefing and evidence on that issue because there are other bases other than just the vice principal's knowledge.
Was that raised in the briefing?
Your Honor, I did discuss in the reply that Mr. Gregg is a low-level employee. He is not a vice principal of the company. And I do want to address Mr. Lee that just misstated a couple facts that I want to make clear. Mr. Gregg was not the one doing the inspections. The manager was doing the inspections. So that's two separate arguments between the knowledge of Mr. Gregg and these inspections being performed that I'm happy to go into if I need to.
Well, in that case, Judge, and if the manager herself is the one doing the inspections, then I think that works because she would be the one with the knowledge of the conditions at the facility. And so then we do have a vice principal or manager's knowledge to support the gross negligence subjective element.
Your Honor, there's no evidence that she saw a hanging ceiling during her inspections. So there's no evidence of knowledge by the vice principal.
And again, Judge, as Mr. Law said, this was raised in reply, and we had a chance to brief or look, specifically submit evidence on this issue. And as you know, the movement is not supposed to be able to raise new arguments in a reply brief, but I am happy to submit a supplemental brief on that if the judge would like to do that. Nevertheless, I think that the more appropriate outcome is to go ahead and reserve judgment on the gross negligence case. And frankly, if there isn't enough evidence at the trial to submit to the jury, then so be it. Then we can, then you can go ahead and say, well, I didn't see enough evidence of gross to submit it. But if we do that now, then we're in a situation where we may not be able to get the relevant evidence into in front of the jury because, and the defendant haven't done this yet, and they may never do this, but I can see a situation where they say, well, that's only relevant to the gross negligence claim, and obviously you've dismissed that already, Judge, so it's not appropriate for you to enter that evidence, for example. I've heard that argument before, so I think it'd be a better approach to reserve on that to the extent that the court is even inclined to consider it based on this new argument, and allow us to develop our evidence at the trial, and then you can make a determination based on a full view.
I tend to agree that if it wasn't raised in the initial briefing, that it's not appropriate, and you can make a new motion for summary judgment. But at this point, I'm not going to entertain that particular argument. So, did you have any other arguments about why gross negligence wasn't appropriate?
Your Honor, if you're addressing me.
Yes.
My argument, it still stands that Mr. Gregg's knowledge that he had prior to being hired by defendant Valiant, regardless of any vice principal knowledge or anything of that nature, it would be hugely against public policy, and no case law was cited by plaintiff that you impose the knowledge that every employee, regardless of their level of employment, has prior to being hired, that you can impose that as a gross negligence onto the company. Mr. Gregg's testimony that was cited is of hanging ceilings that did not occur while Valiant Enterprises managed the property, did not occur within a reasonable time frame before Valiant Enterprises managed the property. And there's no level that you can add that kind of knowledge to support a gross negligence claim against Valiant Enterprises.
And Judge, if I could briefly respond to that, I think that there's two problems with that argument. First of all, I think it is Hornbook agency law that corporations are imputed with the knowledge of their employees who are working in the course and scope of their employment, because obviously corporations don't have minds to think for themselves. They must necessarily get the knowledge from their employees, and it would be inappropriate in this case for that argument to carry the day for the defendants, because there's no basis for them to blame prior managers of the property for a number of reasons, the most significant of which is that they're not a party in the case. They're not, and they're not responsible third parties properly designated by the defendant. And we don't have in front of us in this record any disclaimer of liabilities that Valiant may rely on to say that these prior entities kept any liabilities associated with personal injury actions. I don't think they have that, for one, but also, it's not as part of the record. And so that's sort of an argument to say, well, it's not our problem, it was the guy we bought it from. That's not the way that this should work, especially when they haven't raised that issue in the form of trying to bring a cross claim or a responsible third party action or something of that nature. And in any event, to just go back to the fundamental point, the corporations, I can cite you any number of cases, Judge, but it is axiomatic that the corporation is imputed with the knowledge of its employees. Not just Mr. Gregg, but also the individual who came to fix Miss Jones' dryer, who she pointed this defect out to the day before the accident. So it's not just Mr. Gregg, it's multiple employees.
All right. I'm going to go ahead and take this under advisement, and I will try to get you a ruling within the next 3 weeks. Okay.
Thank you, Your Honor. Do we need to go into traditional summary judgment?
I'm sorry?
Do we need to go into the traditional summary judgment arguments?
No, I think I've read the briefing. I think I'm good.